Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about who owns a lake. Cases that should have gone to the Supreme Court of Canada, but didn't. The Nicola Valley Fish and Game Club in Merritt challenged the Douglas Cattle Company. Essentially, the Douglas Cattle Company owned a large portion of land that surrounded some lakes. The Nicola Valley Fish and Game Club would access the lakes through the Douglas Cattle Company's land because there were no public trails, roadways, highways, or any easements that allowed access to the Fish and Game Company or to anybody else who was interested in visiting the lakes. Because lakes cannot be owned privately, and because the public has a right to use waterways, including lakes, for their own purposes, but do not have a right to trespass upon the Douglas Lake Cattle Company's land, the case went to the court to determine whether or not the Nicola Valley Fish and Game Club had a positive right to access the land. And unfortunately, although they were successful at trial, they were unsuccessful at the Court of Appeal, and the lakes essentially become the private property of the Douglas Cattle Company, because nobody can physically access them, subject to expropriation applications by the City of Merritt. The Nicola Valley Fish and Game Company sought leave to appeal that decision to the Supreme Court of Canada, which was denied. And this case obviously raises fascinating, important legal issues over riparian rights in Canada, something that we very rarely see litigated in court, and in particular, very rarely see litigated at the Supreme Court of Canada. The rights to access water, the rights to use public waterways that are surrounded entirely by private property. And what remedies do individuals have if they wish to access those? Short of landing a float plane onto the property, there's really nothing that could be done that would allow them the opportunity to access the lake and to use the lake, even in circumstances where the evidence showed that there was an ancient trail that was being used by these individuals that wasn't being blocked for a long period of time by the cattle company until they finally decided to assert their rights over their private property. Does that not create essentially an issue of estoppel that says that they can't stop them from accessing it at this point? Can the doctrine of estoppel apply to your right to exclude individuals from your private land? All of this is just fascinating legal issues that really should have gone to the Supreme Court of Canada because of how little these types of cases ever get heard in our judicial system, but how significantly they can impact members of the public all across this country. And as we see land ownership issues becoming far more complex, particularly involving Indigenous communities in Canada, and the disappearance of bodies of water as a result of global warming, these issues are going to become far more significant as time goes on. This was an opportunity for the Supreme Court of Canada not only to engage with a fascinating legal issue, but also to get ahead of what I think we're going to see a lot more of in the future, which is arguments over who can access public waterways. Unfortunately, it'll take another case for the Supreme Court of Canada to hear this, and unfortunately, that may take a very long time. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.